Good afternoon, everybody, or good morning or good evening, depending on where you are in the world. My name is Nick Holland, and I co-head up the privacy team. And joining me today is Sarah Tedstone, who's a principal associate in the privacy and data team. And today we're going to talk to you a little bit about Brexit and data protection. Just a couple of admin points to begin with. Everyone who joins is muted on arrival, and obviously there's various descriptions there about how to control your audio controls. It would be remiss of me as a privacy lawyer not to tell you that obviously this webinar is being recorded, and obviously what we will be doing is sending you an overview of what we've talked about today, plus the slides, plus the recording after the session. It will take about 24, 48 hours for that to happen. And then there is an ability to ask questions, just follow those instructions, and we will do our best to kind of answer as many questions as we can during the session. Forgive us if we don't answer everybody. Obviously, you can follow up with us afterwards, and we'll answer that separately. But obviously, we've got quite a lot to get through, and for the benefit of everybody, we want to be able to get through all the slides. Okay, so we've euphemistically called this Brexit and Data Protection. Will there be fireworks? For those of you in the UK, this is bonfire night, Houses of Parliament with Guy Fawkes. So we thought this would be quite an appropriate day and time to be talking about this. Obviously, there's a lot going on in the US as well. So there's quite and everyone's in some form of lockdown or other around the world. So we thought this was an apt way to kind of describe this session. Next slide, please. So really what we're going to do is take you through the latest on Brexit as it relates to data protection. There's a whole host of other issues relating to Brexit, and we'll allude to some of those during this session as well as at the end and highlight some other sessions we'll be giving, or not, the firm, Schusters will be giving on Brexit. But today we're just going to be focusing on privacy, and there's actually quite a lot to talk about anyway. And yeah, with any moot, Sarah, over to you.
Hello, everybody. Yes, I must admit I thought it was funny to have this on Fireworks Day, but there we are. So I'm not going to dwell, spend a lot of time on the first couple of slides. This slide just indicates a timeline of the transition period for Brexit. Within the 12-month period, although we haven't got that much time left, there's still a fair bit to do, and you can go into the detail of the slide afterwards if you want to see it. As to whether this is going to be a good thing or a bad thing, I'm not sure. Maybe you can tell me what you think after you've heard from us today. I suspect some of what we're about to say may ruin your day, but we will have practical answers at the end, hopefully, that'll help you. So I am going to spend quite a bit of time on this slide because this is important. This tells you the data protection laws that are going to apply after the 31st of December. And sadly, potentially, you could be subject to 3 different regimes. There will definitely be 2 regimes that will be in place after the 31st of December, but there is possibly a third, and I'll explain that now. So the first regime to look at, regime 1 at the top, is the UK GDPR. So the GDPR law, as at the 31st of December, will be enshrined or onshored, however people are describing it, into UK law. It will be called the UK GDPR, and it will have the UK's Data Protection Act 2018 to complement it, which will have been adapted and amended. It will enter into force at 11 p.m. on the 31st of December. And it will apply to any UK businesses, controllers or processes wherever their processing takes place, but also to any businesses, controllers or processes based anywhere that are targeting UK customers, effectively offering goods or services or monitoring them. So UK GDPR applies to you definitely in those scenarios. So you might say, okay, well, I'm complying with GDPR. I know what it is. This isn't a big deal, no difference. And it might feel a lot like business as usual if you're a UK business, certainly. We were allowed a little bit of individuality in applying the GDPR, as all EU countries were. That's what our Data Protection Act did. So we were allowed to have some divergence about age of consent or public interest type processing, or for sensitive special category data. So actually there will be some differences between this regime and the others that I'll talk about, and you'll need to understand those differences if you've got multiple regimes applying to you. If this regime UK GDPR applies to you, the ICO will be the supervisory authority to deal with reports of breaches, complaints, or for guidance that's relevant to you that needs to be applied. So that's regime 1. I'm going to skip to the bottom. I think this is the easiest way to do it and talk about regime 3 next, which is the EU GDPR. So obviously that still exists, and after 31st of December 2020, that will continue to apply to you if you are a business, a UK business, but you have an establishment in the EEA, or you target customers in the EEA, offer goods or services, or monitor individuals. You'll still have to comply with the EU GDPR. Also for any businesses, controllers or processors anywhere in the world, as now, if you've got an establishment in the EEA or you're targeting EEA citizens as customers, offering goods or services or monitoring them, you also have to continue complying with the EU GDPR. For UK businesses, though, there is a bit of difference. The ICO will not be the supervisory authority that will be relevant to you. You'll stop liaising with and working with the ICO about that, and you'll have to work out which supervisory authority will be appropriate. So definitely 2 regimes existing after 31st of December, and you'll have to work out which applies to you. Could well be both. But then there's a third one. If you're a UK business, unfortunately, if the UK does not receive an adequacy decision by 31st of December, which Nick will be going into much more detail about later, but effectively, if we haven't been deemed a safe pair of hands by the 31st of December, and until we are deemed a safe pair of hands, until we get an adequacy decision, there is this other regime. Now, I've always talked about this as being a legacy data regime, but now people are starting to call it all sorts of things. So an adequacy gap or even a frozen GDPR, you'll see it being talked about. And I'm a privacy specialist. I don't deal with anything else, and I'm a total geek about this, but even I'm embarrassed to explain to you the complexity that's involved here and the potential issues for you when you've already gone through GDPR and you've maybe dealt with trends, risks, and here's something else, we're throwing at you. But the background for this, the reason for this is the EU was concerned that the UK may have had personal data shared with it freely from EEA citizens because we're part of the EU, because the GDPR applied to us directly, and we're sort of awash with this stock data by the 31st of December, and the EU was concerned that we might start treating it differently. I don't know what they thought we were going to do with it, but they were concerned enough that the withdrawal agreement enshrined, embedded in the law that we would have an obligation to treat this personal data in the same way after the 31st of December. There's a bit of debate about what version that is, but it seems to be, it may well be the case that it is the EU GDPR that's frozen on the date of the 31st of December. And there's some logic for that. You can see the EU saying, you've had EEA personal data, you've got to continue applying the same standards to it, but we accept, you've got to not keep yourself up to date about all the guidance and everything else, all the changes to it. It's just the law as at that date. So this applies to personal data of EEA data subjects outside the UK, but it's being processed in the UK up until the 31st of December. You have to apply this regime to it. So you can see potentially this will be tricky for you. You've got to understand what data subjects, where it's being processed, and what sort of dates. And potentially you could be subject to all 3 regimes here. We'll talk about this in detail later, and when we're talking about practical examples we'll show you what that means. So there's a lot to get through today. I'm not going to spend a lot of time on this slide. You have the detail, but just to emphasize, everybody's focusing on GDPR, but we wanted to just explain that other rules that are relevant to privacy, we'd also deal with today. So the PECA rules, which you may be familiar with, which deal with e-marketing, cookies, and electronic communications. Within the UK, they are enshrined in UK law, so they'll continue to apply. On a wider basis, a new e-privacy regulation is expected, and if that's relevant to you, you will have to comply with the updated version. It won't be directly relevant in the UK, so it remains to be seen how that's going to be applied in the UK. We just mentioned the NIS directive. Again, in the UK, it's set in UK law, so it will continue to apply. Wherever you're processing, so this is for network and information systems, so we've used a SaaS provider as a typical example. You're probably going to need to know where you are processing, where this is relevant. You'll have local laws to comply with, but just for the avoidance of doubt, it continues to apply in the UK. And freedom of information and environment information regs, again, it continues. You still have to comply. And the UK is a member of relevant treaties anyway on the environment side, so environment regs obligations will continue. I'm just going to very quickly mention this slide now. The UK government published its national data strategy in September. It's out for consultation until 2nd of December, which doesn't leave an awful lot of time after that, but it's sort of an indication of the intention, and it was stated to mean that the UK should be a world-leading data economy, but not having too much of a burdensome data regime, so encouraging innovation and entrepreneurs, seeking adequacy. Nick will deal with that later, but equally suggesting that we might have some alternative cross-border transfer mechanisms, which obviously we've yet to see. We'll wait with bated breath to see what they are.
Thanks, Sarah. So just Sarah's Connie mentioned a bit about adequacy. It's a term that that's bandied about, and as Sarah said broadly, it's a safe pair of hands. So you'll see there, it basically means it's a decision that the jurisdiction, wherever that is, offers an adequate level of protection. There are a number of countries around the world, a bit of an eclectic list of countries ranging from the Isle of Man, Guernsey, to Argentina, Israel, New Zealand, and Uruguay, and a few others, who are currently deemed by the EU to be adequate. In other words, that jurisdiction offers an adequate level of data protection, and you can transfer the data from the EU to that country without there being any additional obligations on you. Obviously, there's a whole set of political negotiations going on between the EU and the UK, and as we say here, it's unclear whether we will obtain an adequacy finding by the end of next month, in effect. You'll see here we talk a little bit about what is involved in acquiring adequacy. It is a lengthy process. So by way of example, Japan was recently granted adequacy, but this was considered a very fast process. I think 2 to 3 years. South Korea is still going through it, and that's been going for a large number of years. Typically, an adequacy decision will take somewhere between 3 to 5 years. Now, obviously, it's possible that behind the scenes, the EU and the UK have been going through this process. If I'm honest, I think it's unlikely that we'll be deemed adequate by the 31st of December 2020. Having said that, who knows, in this uncertain world, something could, a rabbit out of the hat. What I think is entirely possible, that there will be some kind of statement about it and a process by which we will be deemed adequate over the next year or two. And then maybe there'll be some kind of diktat stating, what that means in that transitional period. But your guess is as good as mine. But I think the key thing to think about is that we're not, you can't put all your eggs in one basket and think we're all going to be adequate by the end of this year. And later on, we're going to spell out what this actually means in terms of practical next steps, where we're not granted adequacy by the end of this year, and then some additional things that will mean that you'll also need to do if you are granted adequacy. And so I think historically, what's happened is that the UK have said we're okay for data to be going from the UK to the EU, but the EU have not said the same in return. So I think adequacy is important, and it will be an important part of this process, both now and over the next year or two, in my view, because that's what it will take. But I don't think it's the panacea that people think it is. Next slide, please, Sarah. So more specifically, in terms of on the left-hand side, you'll see these are some of the things that, and Sarah's already alluded to this, that the EU are thinking about the UK when it's considering its adequacy finding. It's not just a question of, because if you on the face of it, you think the UK has been part of the EU for a long period of time. It has implemented the Data Protection Act 2018 to be able to incorporate GDPR into UK law. And of course, has a sophisticated privacy regulator, the ICO, who historically has been seen to be okay, albeit a bit self-regulatory. But having said all of that, you'll see here that they've also got concerns about our mass surveillance techniques. A lot of people forget that when Snowden did his thing back in 2013, it wasn't just against the US. He specifically was against both the US and the UK, which has ultimately led to the whole Schrems, which we'll actually talk a little bit about it later on in this session. There's our membership of the Five Eyes intelligence sharing community. Obviously, there's going to be divergence between UK law and EU law, as Sarah stated in the previous slide. Do we deem third countries to be adequate? We'll no longer be part of the European Union, the Fundamental Rights of the European Union, also the Convention on Human Rights. We've also got the Schrems II judgment, which we'll talk about in a minute, and then there's various immigration exemptions. So those will be all these kind of factors that are being factored into, which is why, I think a lot of us think that the likelihood of us being deemed adequate by the end of this year is unlikely. I'm happy to be proved wrong, though. On the right-hand side, I think this, and I'll spend a little bit of time on this, is just talking a bit about some of the data flows and the complexity of this, which obviously Sarah is kind of taking you through in terms of the three regimes. So if you just look at this on the transfer of data from the UK to EEA, there's going to be some impact, but I think generally we perceive that that's going to be okay. But obviously, over time, regimes may diverge in terms of the UK law will have this set of terms, and then various different laws in the EU or the EU GDPR will be ever growing. And then you've got the transfer of data from the EEA to the UK, and right now, and that's always, and then the EEA have been fairly consistent about this, that's not okay. And essentially, our view is that you are going to have to prepare for that in the anticipation that we do not grant an adequacy. And we'll come back to that at the end when we talk about conclusions, but you're going to have to look at the data transfer solutions and you're going to have to put something in place. And remember, this will apply both to you as a company if you've got operations throughout the EEA and the UK and elsewhere around the world, as well as how you deal with your customers and vendors. It's a two-sided about your internal flow of data as well as your external flow of data. And you're going to have to be able to map that, and you're going to have to be able to then look at the various different options, which again will take you through BCRs, hybrid DTA, model clauses plus to deal with Schrems. And obviously there are some narrow derogations under GDPR in terms of consent, but those are very narrow, very, very narrow. But the precursor to all of this is understanding your data flows, which is always going to be really important. You've then got the transfer of data from the UK to countries the EU is deemed adequate. So the 11 or 12 countries out there. And again, there's going to be divergence between those two suite of countries. But by and large, we think the UK will be fine. So you're getting a bit of a theme here from the UK outside the world. Outside the UK, it's getting to be maybe okay, but coming into the UK, maybe less so. And then the transfer of data of countries that the EU has deemed adequate, those 12 countries that we talked about, to the UK, again, we think that there could be some issues there. Having said that, most have said that they are happy for data to go from those adequate countries to the UK, although I think it's just Andorra, which we're just waiting to hear from. And then the transfer of data from the UK to the rest of the world, again, we think that's going to be okay, but you're going to have to again be aware of where the laws are going to and take into account Schrems. And then the transfer of data from the world to the UK, again, similar issues. So you can see there's a lot of complexity here, and companies are going to need to be able to map their data and understand where their data are going, and then obviously look at it both from an internal data flow as well as with your customers and vendors. And then just to talk a little bit about BCRs, one of my favorite subjects for those who know me well. No UK adequacy. So say we don't get adequacy by Christmas. BCRs, are they still the right way to go? I think as we said in previous webinars, for smaller businesses, perhaps less so, because there's a lot of work that was involved in getting your BCR. But we think for medium and larger size companies, absolutely the way to go. Hybrid data transfer agreements to accommodate SREMs will be the alternative for those smaller companies. But for multinationals, they by far the safest way to go. They future-proof your privacy commitment, both in the UK as well as in the EU, as well as the rest of the world. It will also help you, and indeed it mandates you to keep on top of your privacy program and to keep it maintained. The application to apply for BCRs is now much quicker now that the European Data Protection Board knows what it's doing. And also when you do start to apply, you then get that regulatory protection. Just a brief thing about existing BCRs. So if you do have an existing BCR and the ICO is your lead authority, you will need to transfer to a new authority. And there's a process to follow that. And the ICO has not been accepting any new BCR applications since the summer. And they obviously won't accept anything going forward. And you need to go through a process to transfer over. It's reasonably quick and easy, provided you know the regulator and you know which is the best regulator to go for. And we're happy to help any companies who need that assistance. Obviously, you also have to bear in mind that some BCRs may need to be updated. So if you had a BCR which wasn't GDPR compliant, which the vast majority aren't, then you will need to update your BCR to make it GDPR compliant. And indeed, the European Data Protection was using a useful checklist.
Okay, so we've had a question which I'm going to just park for a moment, and I'll deal with it in a moment. But just to deal with the SREMS issue now, we're getting lots of questions about SREMS. Just to explain, we've done multiple webinars about the SREMS decision, Nick and I, so there are recordings on our website and slides and material if you want to revisit that. But just to revisit it really quickly, SREMS dealt with the Privacy Shield and standard contract clauses and whether they provided adequate protection, specifically for transfers to the US, EU to the US, but the decision had wider ramifications. And I'm sure you know the Privacy Shield was invalidated, and there was big discussion about the standard contract clauses, which I'm going to deal with shortly. And the complexity that adds into Brexit is that standard contract clauses are likely to become a key safeguard for transfers of personal data that the EU GDPR applies to into the UK after 31st of December if there isn't an adequacy decision. And also, as Nick mentioned, there was criticism of the US surveillance regime in the SREMS case following Snowden, which may raise doubts about whether we'll achieve an adequacy decision. So standard contract clauses, question's been asked, is that what we should be doing if we've got data flowing from the EA to the UK, maybe our employee data? The ICO and the government are saying you should be considering standard contract clauses at this point, or safeguards generally, but standard contract clauses are probably going to be a key safeguard for you for protecting that flow of personal data from the EEA to the UK. You should be thinking about it now. If there isn't going to be an adequacy decision, the European Data Protection Board ominously suggested there wouldn't be any sort of moratorium, and there has been a suggestion that we've had a transition period of 12 months, so we should be, already for this and have been thinking about it. So if you're looking at standard contract clauses in that scenario, we, within our solution to SREMS, advised of our SCC Plus model to deal with the risks of SREMS. So SREMS said that the standard contract clauses are not just a paper exercise. The criticism within the case was not really about the clauses themselves, but the way that they've been used, which was not how they were intended to be used. So our SCC Plus model, if you're using standard contract clauses at all, this applies to them being used at all, but we're obviously focused today on where we might be needed them for the flows from the EEA to the UK specifically and anywhere else as a result of Brexit. We say, first of all, you need to update your ROPA, your Article 30 record, because you can see from what we've been saying so far, you need to understand what you're doing, your locations, your data subjects involved. and then assess what safeguards might be needed. For this, I'm going to assume you've decided that your standard contract clauses are the safeguard you want. And as I've said, they are a contract. Just signing them, putting them in a drawer is not going to achieve compliance. It's not going to be just the safeguard on its own that you need. I'd recommend that you understand the obligations within them. I'm not saying necessarily read them fully. I've done it multiple times. We can help you with understanding more easily the obligations within them, but there are really significant obligations within them. Times when it says that you should obtain legal advice about them, there should be monitoring, you should make formal decisions and record them before you can justify a transfer, or maybe terminate the contract or not transfer otherwise. But we can help with that if that would be useful. Then we say almost you need a mini DPIA with any transfer to justify it, which again means knowing the locations involved for that specific transfer, looking at whether it's a risky location that's involved, are there specific prohibitions on the specific transfer. We're seeing them already for particular locations. We're tracking this globally, we can help, but look at enforcement obligations. So specifically, the US surveillance regimes in particular, the US has been criticised, but other locations are also seen to be risky. Any conflicts with GDPR data protection standards involved with the location, look at whether rights and claims can be enforced and your particular industry. And contractual policy and notice type updates that might be needed. You might need additional terms in your contract, whatever that is, your hybrid DTA internally or your contracts that are going externally, to supplement the standard contract clauses to deal with, in particular, if you get a law enforcement or surveillance request for data, how you can deal with that, possibly push back or, push the risk back onto the exporter that should be having that discussion with them. You'll need to update your due diligence processes with third-party suppliers and vendors to understand, the risks involved there and locations. And I would say if you're having to justify your transfer and, if you're challenged justifying it, that's going to be tricky if you can't show you're compliant behind the scenes. If your sort of business as usual, privacy by design and default isn't in order, that may be tricky if you're challenged. And I'd say have a compliance plan in place. We do them routinely day in, day out. If you're assessing the risks of what you haven't yet achieved and you're prioritizing it, that may give you a little bit of protection for things you haven't yet managed to do if you can show that you've understood your risks and you've had a look at it. And clearly you've got to monitor developments in this area. You're going to need what's changing. We're expecting updated standard contract clauses. UK government has got to approve them, ironically, for use by the UK, but we're expecting that to happen. But there may be new versions. Again, we've already been told they're not going to solve the Schrems risk. They're not going to have all the answers. There's still going to be all this kind of work that needs to be done as well.
Yes, so the bottom line is you still have to do all that work, notwithstanding the EU is not going to swap one set of standard clauses for a new set of standard clauses you just sign and put in the drawer. So you're still going to have to do all that work that Sarah's outlined. So moving on to another issue is the UK representative, which is analysis to the EU representative. And this will apply, and a lot of people aren't necessarily aware of this, but this will apply to any business outside the UK which has no physical footprint in the UK and either monitors individuals, UK individuals, or targets them in the UK. So it could be that you're tracking cookies. It could be you've got a website somewhere in Europe or the US or China, Brazil, wherever in the world, and you're monitoring and set to people located in the UK. And note I say there were people located in the EU, not UK citizens. And you're targeting them, and of course you're doing the obvious selling or shipping products to them. You will need to appoint a UK representative, and this is irrelevant whether adequacy applies or not. There's nothing to do with that at all. This is a mandatory obligation that will affect all international businesses who are doing business in the UK who do not have a physical footprint. And for a lot of people, they're thinking, oh, I didn't know about this. So and when we obviously, hopefully we've got a nice solution for you. Next slide, please, Sarah. So what does this UK rep have to do? So the UK rep, it's quite an easy process. It's about maintaining, assuming you have them in place in the first place, a record of processing required under the Article 30. In terms of your understanding of data flows and data mapping, this person will also facilitate comms between individuals and the controller processor, and between the regulator, the ICO, and the controller processor. So a bit of a conduit. And it will also provide information to the ICO. So the ICO it will be a registered appointment, and the ICO will then contact the UK rep if there's a problem, or you will contact the ICO if there's a problem. And hence you're a named point of contact for UK data subjects. And it is all designed to assist the data subject in the UK who doesn't know how to contact or can't deal with a company who's not based in the UK, hence why you have this UK representative. What this thing will not do, what the UK rep will not do is deal with data subject rights in terms of data subject access requests, or kind of give legal guidance, as you would do, for example, as a DPO, on commercial strategies or legal rights and obligations. It's purely a kind of administrative task. And in light of that, I'm pleased to say that we're launching our kind of UK representative services next week. And we wanted a fixed price, platform-based service available to any business who obviously needs to appoint a UK representative. It'll be provided by our privacy services subsidiary of Shoesmith LLP. And we're also likely to be launching an EU rep service, because although an EU rep service will apply to any company who's based in the UK who does not have any EAA operations, but is also selling to people in the EEA or tracking people in the EEA, and therefore they will also have to appoint an EU rep. However, the deadline for that, there is no deadline. You don't need to have that in place by the 31st of December 2020. And we are likely to be launching that service in a month or two thereafter. But obviously the priority for us is launching the UK service, because that is a deadline. And obviously we'll be sending out details to affected people next week. And then obviously as and when we're ready to launch the EU rep service, we'll be sending that out to everybody as well.
So Nick, we've had a question coming while you've been talking. So it says, a group DPO located in the UK, can that fulfill the requirement of the UK rep?
No. So you can't have a DPO who's also going to be the UK rep. It will need to. Well, you can. That person will also need to be registered as the UK rep. But you will be able to kind of. You will be able to combine the service. So if you've got a DPO, that DPO obviously can support you globally. And not just in the UK and the EU, but it will need to be a separate appointment, but it could be the same person.
And I will deal with DPOs later. Sorry. So DPOs next. Yes, we were going to come to this. So just to be absolutely clear, if you're required to have a DPO, the requirement will continue under whatever regime. If you've got a DPO in the UK, that can continue, and your DPO can cover multiple locations, so can cover the UK and the EEA. The only new requirement, or the requirement that will probably go across both regimes, is that your DPO must be easily accessible from any establishment, so you may need to think about that, but also, and this may be of more concern, they must have expert knowledge of all regimes that apply. So the regimes I talk about, UK GDPR, EU GDPR, and the legacy data regime, or whatever you want to call it, your DPO must have in-depth knowledge of each of the regimes, how it applies to your business, and the differences, and that is a requirement.
So, and just as a follow-up to that one, so often companies will have, for example, a German DPO, because that's a legal requirement. From experience, the German DPO will just typically only be able to advise on German law, and therefore would not be suitable for that kind of role. But you obviously need to make sure you've got the right person who has that kind of, at the very least, UK and EU knowledge, but preferably global as well.
Okay, and we've had a question that says, in terms of EEA supervisory authorities, do they need to be appointed? Is there a specific procedure to appoint? Well, Nick's dealt with representatives being appointed. I think if the question is about finding out which supervisory authority applies, I referred to that earlier, and Nick will deal with it in a little bit of detail, but just to be clear then, yes, where you're dealing with UK GDPR, the ICO will be the supervisory authority that will be applicable. But if you're talking about the EU GDPR, then yes, you will need to consider which supervisory authority is appropriate. It's not a question necessarily of an appointment, but there are specific guidelines that you can use to decide which is the appropriate supervisory authority, and it may be that your location of processing within the EU will dictate that. But Nick will deal with that, refer to that a little bit later.
Yeah, and just an additional follow-up to that, I mean, that's another reason why you need to make sure your DPO is knowledgeable about a number of other jurisdictions, because obviously some DPAs in Europe are harder than others and more difficult to deal with, and they're all slightly different, and they're slightly different foibles. So you need to make sure you're aware of that and choose wisely. I'm
not going to spend a lot of time on this, but just to flag really that if you're a UK business, at the moment we benefit from the ICO being part of what's called the one-stop shop, which is sort of cooperation between supervisory authorities across the EU EA, which means that you can almost deal with one supervisory authority as a lead, where there are multiple, where we're talking about cross-border jurisdictional type issues. And we've benefited from that at the moment. That has continued throughout the transition period, but that is about to stop. So, as we've said, the ICO will not be your regulator for European-specific activities or EU GDPR type processing. We're expecting cooperation, and I suppose it's a little bit of sort of wait and see how this is going to work. I'm going to mention cookies here really quickly. Just as a bit of, we've chosen this as a bit of an example really of what might happen. So cookies and consent, there's been recent EDP guidance, European Data Protection Board guidance on consent, and the French Supervisory Authority CNIL has updated its guidance on cookies recently. The ICO has yet to clarify its position. So what would be your position about this? How would you proceed with this? So I think the guidance is that, just for the avoidance of doubt, that you can't say, for example, when you ask an individual when browsing the website to say if they continue to browse, that's consent. And it has to be a clear positive action to indicate consent. And the strict interpretation of the EDPB guidelines would say that consent needs to be so specific that it should be separate for a particular company doing direct marketing and then sharing it with group companies. So what would you do in this situation? The position will be that if you're within the EU GDPR regime, then you're still bound by EU member state laws and ongoing guidance. And it remains to be seen how the ICO will react to this for where it is a regulator for the UK GDPR regime. We mention cookies particularly because we feel that there's an awful lot of websites that still aren't compliant. I don't think businesses realise that the position has moved, that guidance has updated. And anything on your website can be a big red flag. If it's not compliant, it's an easy win almost to have your website compliant to give reassurance. But if it isn't, it can be a real red flag as to possible other non-compliance internally.
Okay, I'm conscious there's still a few questions. We'll try and finish with the next few slides and come back to some of these questions. So just to highlight a bit about what's for the UK government to do now, there's a lot that they need to do. But obviously specifically implement, as Sarah said, the UK GDPR, how to deal with the legacy data scenario, that's the regime 2 that Sarah talked about, adopting the existing SECs for use by the UK, promulgating a clear view of how to deal with transfers out of the UK to the EEA and the rest of the world, the whole adequacy arrangements both to the EEA and non-EEA countries, as dealing with obviously the UK adequacy, and then how is the EU deemed, and then how to deal with the EU deemed adequate countries recognising the UK. There's a lot for that to happen. Is that all going to happen by Christmas? Who knows? But I think as we come on to the next two slides, I think, or next slide, this is a kind of our checklist of things that we think companies will need to do and must do between now and Christmas to kind of, or as best as they can, to get themselves compliant. So for you to do now, and you'll see that this is important, there's an asterisk here if there is no UK adequacy. So what we try to do is highlight all the areas that you need to focus on, and then and then there's an asterisk where if there's no UK adequacy, what you need to do. So first off, comply with the GDPR. And I know that sounds really obvious, but I mean, if it was so obvious, I'd be out of a job, as would Sarah, because we wouldn't have any work to do. There's still many, many companies out there who are either done something on GDPR in or around the summer of 2018, but haven't looked at it since, or just put in some pieces of paper from a law firm, and then they think they're compliant. Or there's companies who are still on their proverbial journey of compliance. Either way, you need to continue to focus on that, and if possible, speed that process up. So comply with the GDPR. Then you need to understand what GDPR regime applies to your business. So Sarah went through that slide about the three different regimes. Is it the UK GDPR? Is it the EU GDPR? Is it the legacy data regime? And which supervisory authority are you going to be dealing with? Is it the ICO, or are you transferring data into the EU, and therefore you need to be aware of what the different supervisory authorities around Europe. Just because a UK company is not always just going to be the ICO, and you need to be aware of that, and you need to understand that. How do you understand that? Well, you understand that by focusing on your data flows and the locations involved, and that's important not just because it's a legal requirement, whether you're in the UK or the EU. But it's going to be so important for understanding what you do with what type of data with your regime, but also how to comply with SREMS, which is a key component of your compliance going forward. So you really must focus on your data flows, and we obviously are here to help you do that. First, and you'll see that so if there is no adequacy decision, if there is no adequacy decision for legacy data regimes, you're going to have to differentiate between personal data collected before Christmas or 31st of December, and whether it's of UK data subjects or not, and whether it's processed in the UK or not. And you're going to have to kind of identify that and deal with it. You're going to have to appoint the EU and UK representatives, well, particularly the UK representative. And just one of the questions is, there is no deadline for appointing an EU rep, so you will not need to appoint an EU rep by the 31st of December, but you will need to appoint a UK rep by the 31st of December. The EU rep can happen in 2021, but the UK rep must happen this side of Christmas. That's if you're don't have an operation in the UK and you're targeting the UK. And just link to that other question that I've just seen about is the obligation between DPO and the UK representative. They are different. The DPO is a much broader, wider set of obligations, typically global, whereas obviously UK rep is just talking about the UK. And I would have thought that if you've got a DPO, that person will probably be different from the UK rep, because your DPO, if you're having to appoint a UK rep, your DPO is not likely to be based in the UK, because otherwise you wouldn't have a UK rep, and therefore they're probably not familiar with those obligations. You'll need to check whether the UK has recognised adequacy of the EEA and relevant global locations, and obviously we're keeping a very close eye on that, but that will be important to understand once you've understood your data flows. Where's that going? Is it adequate? This is quite important. You review your privacy notices, DPIAs, and other documentation. So, for example, what you'll often see is in privacy notices, you see it quite a lot, is that they will say that data is processed exclusively within the EU. Of course, that's no longer going to be applicable because the EU will not contain the UK. So there is going to be quite a lot of review of existing policies and procedures to be able to differentiate between the EU and the UK and see how that applies to your privacy notices, your data privacy impact assessments, and other documentations that have obviously historically referred to EU law, which will no longer be applicable. Ensure your DPO is accessible both for your UK and other EU establishments, and that they have the knowledge to do that. We also offer DPO services with expertise globally in this area. And then obviously your data flows, hugely important. Obviously a little bit depending on whether UK adequacy, going for BCRs, hybrid DTAs, SEC pluses. And as Sarah said, there's a whole where we can obviously send you the links to all that's on our website for all the links for the Schrems decision, where we go into spend 3/4 of an hour talking just purely on that area. I'm conscious of time, but Sarah, the next slide. So just quickly, we've got a whole Brexit hub, as I'm sure all law firms do. Please go on to it. There's a whole raft of information. And next slide, Sarah. And then there's a few other webinars that are happening, principally on the employment side, which my colleague Rachel Harvey is giving in November and early December. And depending on what pans out, we may well be doing another one of these purely on Brexit, either in December or early 2021, depending on the processes, timescales. Sarah.
I think we've dealt with all questions actually, but we will do a sweep of all the questions afterwards, and we'll follow up if we feel that we haven't answered any particular questions. And feel free to reach out to either of us if you do have questions. But I think otherwise we're there. The slides will be available to you all, as will the recording and a summary note of the key issues.
Thank you all for your time. I hope it's been helpful. I appreciate it's quite a rushed ending. Hopefully the last slide talking about what you need to do is fairly clear. We're obviously here to help you, and thanks for your time, and have a good rest of the day.